So my name is Richie Bosman. I'm bringing to you unpopular law cases. For this case, in Germany, a tenant moved out of an apartment after living there for some time. When the landlord inspected the bedroom, he noticed that the marble flooring near the toilet had been damaged. The landlord believed that the damage was caused by the rain splashes from a man who lives in West London. So he then demanded compensation from the tenant, arguing that the tenant's habits of standing while urinating caused permanent damage to the marble floor. So he shouldn't have stood while urinating, he should have sat down as to use the toilet. So the question here, the main question that arises in this case is it really wrong for a man to urinate while standing in a rented apartment? It is normal for men to stand up while urinating. So the court had to decide, is it really wrong for a man to urinate while standing in a rented apartment? The court ruled in the favor of the tenant. Now the court held that urinating while standing is a normal and socially acceptable behavior of the man. Tenants cannot automatically be held liable for doing so. Men do stand while urinating, so it's a normal thing. So because of this, the landlord could not claim compensation, based simply on the argument that the tenant should have sat down. Tenants are not liable for ordinary and socially accepted usage of the property. You understand? This is ordinary and socially accepted usage. This is normal thing. This is a normal thing for us. Just like saying that women couldn't bend down while you wait, women couldn't. I mean, it's a normal thing. And men, like the man was standing, is a normal thing. And any damage that comes from that, the court won't hold the man liable, won't hold the tenant liable for that damage, because it is normal, social, and acceptable usage. Because the tenant is only responsible for unreasonable usage, unreasonable misuse of that property. That's not unreasonable and intentional misuse or damage of that property. But if it's like normal, socially accepted way of doing, socially accepted way of something occurred while applying that socially acceptable way of doing things, the tenant or the person in question will be held liable for such acts. When someone rents a property, the law expects that the person uses the property reasonably, you understand? But then the law also recognizes that ordinary human behavior will naturally cause some level of wear and tear. You understand? So if owners were allowed to claim damages for every normal activity in a house, tenants could, constantly face legal claims for things that are simply part of daily life. So the court essentially say, standing while urinating, sometimes cause splashes, urine may splash, you understand? So, but it's not an abnormal behavior. It's not an abnormal behavior and cannot automatically make a tenant legally responsible. The person to pick up on this case is the law only punishes unreasonable misuse. So even though the case may sound funny actually, but it teaches a very important principle about the misuse of rental property. So if you want to understand more unusual cases like this, you can join my WhatsApp channel through the link on the panel. And my name is Richie Bosman.